Good morning, how are you? Back to it, part 3. Today's video, we're talking about appeals with the Board of Immigration Appeals. Should I file a notice to appeal because the immigration judge has ordered me removed, or the immigration judge only order or decided that only withholding of removal is warranted under my circumstances. Should I file for an appeal? The simple short answer is yes, you should file for an appeal. In this video, we're going to talk about it. My name is Bijoux, Ngwanda, immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, you know what to do. Please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. Please do not forget to hit the notification bell so you don't miss out on anything. Enjoying the content, please go ahead and like, share. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. When exactly should I file for an appeal? Within 30 days of the immigration judge decision. If you file late, you have to come with a reason, right, that prevented you from filing this appeal on time. And most of the time, really, to be honest, those reasons, the case will be dismissed basically just because it's late and there's no exceptional circumstances preventing you from filing sooner, okay? Out of 10 cases, maybe 2 people will win a late motion for late filing, but just stay within the 30 days, okay? The decision is entered, you don't agree with it, file for an appeal. Why? Because the way we look at removal proceedings, we look at it as a long-term game. First reason or main reason you want to file for an appeal is because you want to prevent ICE from executing the removal order. Nowadays, sometimes a person can argue that my appeal was pending, they still deported me. We're not talking about those exceptions, circumstances that things are happening like outside of the norms. We're talking about like under right circumstances, because that's the case for most people that I've worked with, okay? Even under this administration. Once you file for an appeal, it stays the removal order. Meaning what? It prevents ICE from deporting you, because now you're asking for the Board of Immigration Appeals to look at the decision and determine whether or not the judge made a mistake, factual mistake, legal mistake, or you abused their discretion. That's the reason you're filing for an appeal. So why, again, should you file for an appeal? You want to stay the order of removal. What about the person who's detained? Well, I am detained. Should I still file for an appeal? Of course, you want to file for an appeal, especially if you're detained. The reason, now we're talking about people who are outside, they can tell their family members who are detained, right? The reason a person who's detained really has to file for an appeal because, first of all, they are under ICE jurisdiction, DHS, right? When it comes to deportation, they're already under ICE jurisdiction. ICE is not going to go outside looking for them somewhere. They're already there. And it's faster for ICE to exercise that removal order. So that's why you want to file for this appeal. And not to mention, you want to maintain jurisdiction where you are detained, because you want to avoid transfer and stuff like that. So we've been able to do that successfully. So file for an appeal, okay? What are the reasons now a person can file for an appeal? The person files for an appeal because they find that the immigration judge made a mistake, legal error, mistake of law in applying the law. They make the mistake. Factual error, they made a mistake with facts. Mixed error of law and fact. They abuse their discretion, discretionary error. You know, because asylum, again, is a matter of discretion. Even if you meet the requirement, the judge can still weight positive factors and negative factor and decide whether or not the person merits asylum, okay? But if you feel like the discretion that they use, it's basically a harness, like it's this mistake while they're using their discretion, you can file an appeal based on that. Procedural due process, that's a mistake of law. And some facts too can be there in terms of if the judge did what they're supposed to do when the person is not represented by a lawyer. So this is mixed. So when it comes to procedural due process, basically you're claiming that they did not give you the right to have a lawyer or a reasonable time to find a lawyer. That's the case with somebody who arguing because they detained the person went to a hearing without a lawyer present. They didn't give him, according to our reasoning, they didn't give him reasonable time to find a lawyer. Reasonable time will depend on the circumstances, and it will just depend on what is really reasonable under that person's circumstances. We find that it wasn't reasonable, and we have a strong opinion that the BIA will agree with us. The person wasn't given reasonable time to find a lawyer to represent them, so the judge ordered the person removed. We filed an appeal for that, okay? Based on that alone. We have filed an appeal based on legal error. If we feel like the judge should have applied this standard, they applied this standard, we file an appeal. So if you look at the decision of the immigration judge, there's always something to find in order to file for an appeal. The question now becomes, am I going to win for when I file? It depends. It depends on what the Board of Immigration is going to decide. But remember, you're filing for an appeal because, first of all, you want to not be deported. And meanwhile, while the appeal is pending, because those appeals sometimes take too long, especially for people who are not detained, when the appeal is pending, new evidence can come to light. Evidence that were not discoverable when the case was adjudicated by the immigration judge. So you can introduce those new evidence and file a motion to remand so they can, send the case back for a second hearing. So that's why you want to file, and really you want to file for an appeal, because you need time to think while you're still in the United States, especially if you're not detained. Then you have the right to work, because if you had your work permit, you still have your work permit is still valid, and given the time that the appeal is going to take, I mean, you can still work, save, and if you decide to later just move on with your life or leave the country, at least you will have the money that you have saved, and you have the time to prepare to just leave, if that's the choice you decided to make. But you really have to file for an appeal, because you have to look at the removal proceedings as a long-term game. Detained, still you file for an appeal, because you're already under ICE jurisdiction. Anytime soon they can execute the order of removal if they don't see an appeal within 30 days. Okay, they will execute the order of removal. So you have to, if you don't want to be deported within those, after 30 days of the immigration judge order. So you file for an appeal. Meanwhile, you start looking on whether you can be released. That's the subject of the second video. We're going to be talking about bond hearings and all that. So, in conclusion, appeals under this administration, can I file? Should I file? Simple answer is yes, you want to file, because you really want to maintain the record, especially if you feel like the case is strong and you're going to later on, if the BIA doesn't agree with you, you want to go back to, you want to go to a federal court, a circuit court, for them to review the decision of the BIA. If they don't agree with you, yes, you have to file for an appeal. Number two, you file for an appeal because you need time to think. Maybe new evidence will come to light, especially if you were not represented before, and now you have a lawyer. You really have to file an appeal so they can give you a second chance to present your case again. You file an appeal because it states the order of removal. We've said that. You file an appeal because you want to see if there's other ways you can file a motion to remand so that they can remand your case back for a second hearing. You file an appeal because you just don't agree with the decision. So that's why you file an appeal. Simple answer is yes, you should file for an appeal. For consideration of appeal, if you need a consultation with me, we're here to help. Please schedule it by using the consultation link in the description box below. Until next time, bye bye.